Welcome to ANN News. I'm Edward Softwater reporting to you today on March 5th, 1857. We actually have the pleasure of talking to the Supreme Court Justice, Chief Justice Roger B. Taney, on the eve of a momentous occasion for the country on the debate of slavery. Your Eminence, welcome. Thank you very much for coming. Please have a seat.
Could you please refer to me as Your Honor? Thank you very much.
Your Honor. I apologize, Your Honorship. Could you give our TV audience the decision that you plan on giving tomorrow?
Well, I can give you the same story that I told President James Buchanan right before his inauguration. I told him that my decision was going to put an end to these long-standing agitations by these tiresome abolitionists, that they were going to have to shut up when they heard what I had to say. Let's just have a listen here to this. Upon a writ of error to the Circuit Court of the United States, the transcript of the record of all proceedings in the case is brought before the court and is open to its inspection and revision. When a plea to the jurisdiction in abatement is overruled by the court upon demurrer and the defendant pleads in bar, and upon these pleas the final judgment of the court is in his favor, if the plaintiff brings a writ of error, the judgment of the court upon the plea in abatement is before this court, although it was in favor of the plaintiff. And if the court erred in overruling it, the judgment must be reversed, and a mandate issued to the circuit court to dismiss the case for want of jurisdiction.
Thank you, Judge. How long is that?
It's 44 pages.
44 pages.
Yes, sir.
I really don't think our TV audience has the time or patience for such a pompous, long-winded monologue. Could you just maybe give us the conclusion?
Well, I really think that they should hear the whole thing to see how I...
Yeah, but we're in time constraints. Our sponsors would pull out. So just the conclusion would be great.
Well, let me get to page 44.
Okay.
Just a moment. 45. Here we are. Upon the whole, therefore, it is judgment of this court that it appeared by the record before us that the plaintiff in error is not a citizen of Missouri in the sense in which that word is used in the Constitution, and the Circuit Court of the United States, for that reason, had no jurisdiction in the case and could give no judgment in it. Its judgment for the defendant must consequently be reversed and a mandate issued directing the suit to be dismissed for want of jurisdiction.
Okay. You know, that's not really very interesting either, Your Holiness. Could you give us maybe a gist or a summary?
I have a brief summary here, yes.
Great. It's in English, right?
Yes, it is.
Good.
Let me see. Here we are. That the Declaration of Independence and the Constitution of the United States do not include nor refer to Negroes otherwise than as property, that they cannot become citizens of the United States nor sue in federal courts, that Dred Scott's claim to freedom by reason of his residence in Illinois was a Missouri question, which Missouri has decided against him, that the Constitution of the United States recognizes slaves as property and pledges the federal government to protect it, and that the Missouri Compromise Act and like prohibitory laws are unconstitutional, that the Circuit Court of the United States had no jurisdiction in the case and could give no judgment in it and must be directed to dismiss the suit. Now, I think anyone with a grade school education can understand that one.
I think so. Well, thank you very much for coming on to our show and sparing us the 44 pages. I hope you'll be received kindly by your fellow slaveholders in the South, your wife and your dog.
Well, I don't have a wife, and as for my dog, I just can't get him to growl louder when a Negro comes in.
Right. Good luck getting past the mob of reporters at our door. Thank you very much. I'm Edward Softwater, and that's our story. We'll be right back after a message from our sponsors.